Welcome everyone to this Privacy Rules Privacy Espresso episode. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules. And today I'm joined by Protiti Basu from the law firm Wodianka Legal based in Germany. Protiti is an expert in GDPR and Indian law as well. And, also in connection to our last episode of the Privacy Espresso, where we were speaking with our member from India about the Indian coming law. Today with Protiti, we are going to delve a bit more into the differences between this law and the GDPR. So we will focus on that. So first of all, Protiti, thanks a lot for being with us today. It's a pleasure to have you here.
Thank you so much for having me. It's a pleasure to be here.
Great. And, let's move forward because the time is very strict in our Privacy Espresso series. So as first thing, can you provide us with a little overview on, the changes and the differences between the GDPR and the Indian coming law?
Of course. Before I go into the changes, I just want to start by saying that the Indian law is more or less very similar to that of the GDPR. It is heavily inspired by that of the GDPR. However, the Act has left a lot to be done and to be supplemented in the future by rules issued by the government. Now, what this effectively does is, because so much of it is left in the future, at this point, the effect of the Act can only be known in full once these rules are issued and they are in effect. So these rules can either be more in line with the GDPR or they can head in a completely different direction and be very different from that of the GDPR. So the comparison that I'm trying to make right now is based on the current draft of the new law. So with that being said, let's head to the differences. The first one, and probably the most apparent one, is that of the nomenclatures of certain actors. Under the GDPR, controllers obviously are called data controllers, whereas under the new law, they're called data fiduciaries. Similarly, data subjects are called data principals. The term for processors remains the same between the both, so there's no issue there. Next, moving on to the scope and applicability of the new law. Again, I think the new law is more or less in the vein of the GDPR in terms of the concepts of the applicability and scope. However, there are three significant differences. The first being that while the GDPR makes a difference between personal data and special categories of personal data, the new law does not make any such distinction, which is interesting because the predecessor to the new law, the SPDI rules in India, was specifically tailored to sensitive personal data and their protection. So it's interesting that the legislature right now thought that, let's do away with that and treat every personal data on the same level. The next difference I want to talk about at this juncture is that, unlike the GDPR, the new law does not include publicly available personal data within its scope. It is completely excluded from its scope of application. And thirdly, the GDPR applies to processing by automated as well as non-automated means, which form a part of a filing system. However, the new law only applies to digitalized data or non-digitalized data, which will subsequently be digitalized, which means that any sort of purely non-digitalized data is not covered under the new law. We can, I think, now that the applicability and scope is over, we could move on to data breaches. Now, the new law requires the controllers to mandatorily report every data breach to the supervisory authority, and in a first for India, to the affected data principals. Now, this is interesting because the GDPR is not so strict in its reporting. Well, the GDPR says that when there is a risky data breach, that needs to be reported to the supervisory authority. And like data breaches which pose high risk to the freedom of data subjects, those need to be reported to the data subjects. Now, what is interesting here again is the fact that under the current law, India already has a data breach reporting system. All data breaches have to be reported within 6 hours to an authority called the CERT-In, which is specifically put in to deal with situations like this. Now, once the new law comes into effect, in essentially, controllers would have to report to two places. One, to the CERT-in, and secondly, to the supervisory authority under the new law. And the CERT-in was in place because India did not have a supervisory authority. So now that the supervisory authority is finally put into place, it's really interesting to see what the future lies for the CERT-in. Will it be discontinued? Will there be a share of powers with that of the supervisory authority? I think the government would obviously come up with a plan for that, because it seems unlikely that there'll be two parallel reportings going on side to side, but that's going to be an interesting direction to see where the law changes. Next, I want to talk a little bit about data subject rights. Again, I think most of the data subject rights under the new law is similar to that of the GDPR, but significantly, the new law does not have the right to data portability given to data subjects. Most of the other rights are covered. Now, coming to notifications, which are to be given to data subjects. Under the GDPR, under Article 13, when collecting data from data subjects, the processor has to notify the data subjects of various things, including, the reasons of processing, the means of purposing, etc., etc. But under the new law, this notice has to be given when consent is the legal basis for processing. Now, the GDPR does not make any such restrictions. For the GDPR, whenever data is being processed, you have to give such notice. So this is an important distinction between the two laws, because also the form of the consent notice under Article 13 under GDPR is very wide. The Indian law is very narrow in terms of giving such consent notice to data subjects. Next, I think we can talk a bit on the age of majority when processing children's data. So in India, the age of majority for processing children's data is 18 years old, whereas under the GDPR, it is 16, and in certain cases, 13. So effectively, what this means is processing of personal data for any person below the age of 18 requires consent from their guardian. And I think one really interesting bit about the Indian law, which is not there in the GDPR, is, and I think I will read this out because it's a specific prohibition that the law imposes on controllers, which says that any controller cannot, it basically prohibits tracking or behavioral monitoring of children or targeted advertising directly at children. This is important because the GDPR does not have any such specific prohibition towards processing of children's data, but the Indian law makes it very clear that all of the scenarios cannot happen. I think lastly, we could move on to cross-border data transfer, which is obviously a very exhaustive and detailed topic under the GDPR. And I think this is one of the areas where I think that the Indian law falls short, and it could really improve more, because for cross-border data transferring, what the Indian law says is that the Indian government would come up with a negative list of countries where data cannot be transferred, and to every other country, essentially you can transfer data. Whereas if you see the structure under the GDPR, there are SCCs, there are adequacy decisions, there are BCRs. It is so complex, it is so nuanced, and they offer a lot of protection. So I think India really needs to do more in this area, especially, and bring their data transfer standards to, I think, to a level which is parallel to that of the GDPR. Yeah. I think in terms of differences, these are the main differences. I would like to, I think, also briefly touch upon certain concepts which are, let's just say, new to the Indian law, but they do not have a they do not have like a corresponding GDPR base.
I have a question, Protiti, for you before we move forward, because it was very interesting what I was hearing, and various points. The data breach one was already concerning in the past. We were speaking with our Indian expert about it, and of course knowing that it's still there then makes people a bit worried, because 6 hours to notify
Yes,
an authority and
exactly.
that it's sounds very difficult or very hard, let's say. Last but not least, of course, as you were saying, I think that there are also some differences of provisions that we have that you have in the Indian law that we do not have under the GDPR. So maybe you can go a bit deeper on that, but we just have 2 minutes, so
Yeah,
very
I'm going to quickly run through that. Firstly, is interestingly, they've made difference. They've introduced this entire concept called a significant data fiduciary, which is uh, a special category of data fiduciaries, which have been called such because, quite possibly they process data which is of high volume, high sensitivity, which possess great risk for the freedoms of individuals, or they are a threat to national security. So these significant data fiduciaries are therefore subject to a much higher level of they have higher restrictions, and they have to put in more safeguards. So I think, and like, for example, they have to set DPOs, they have to appoint external auditors, they have to conduct periodic DPIAs, which normal data fiduciaries do not have to do. So I think there is no concept of significant data fiduciaries which can be found in the GDPR. However, data controllers in the GDPR do also have to, appoint DPOs or conduct DPIAs in cases of high risk data processing. So I think the underlying concept is there, but there is the differentiation of data fiduciary of data controllers isn't there essentially. The next topic I would like to talk about is that of a consent manager. This is a brand new post which has been created under the new law. Essentially, they serve as the middleman between the data subject and the data controller, and they help the data controller in managing their consents. Most of their roles have not been defined yet. Like I said, it's to be given under rules which are to be issued later in the future. So that's one we should look forward to. Next, I'm going to quickly talk about an additional data subject right, which has been given to data subjects, which is called the right of nomination, wherein a data subject can nominate a third party who, in case of his death, can assume all his powers under the act and, exercise his powers, which is really interesting and is not something which is found under the GDPR. And lastly, I'm going to talk about a redressal mechanism wherein data subjects under the new law have to firstly go to the data controller in case they have a grievance and exhaust their the grievance redressal which is there with the data controller. And once they have exhausted that, only then can they go to the supervisory authority and file for a complaint. I mean, there is no equivalent in the GDPR for that. The GDPR does not make such distinctions. I think it just allows you can go and apply wherever.
Perfect, perfect. That sounds extremely interesting, and thanks a lot for sharing your knowledge with us in this comparative manner, because that's very useful. We are very used to GDPR today. Of course, we don't live in a GDPR centric, but by being used and comparing things, it's easier to understand which are the differences we should keep in mind. That in this case is quite a lot of differences, but as you said, probably we can expect new changes from the Indian perspective, because there are still some parts that needs to be covered, quite not a lot, but some
just more fine-tuned.
Like for data, the part related to data transfer is definitely something we are looking forward to hear more about. But thanks a lot for your time and for this
You're welcome.
Nice comparison. It was a pleasure to have you and also our listeners with us today. So looking forward to meet you all with our next episode of the Privacy Rules Privacy Express.